Fast forward, yini komo ewo na yiso aha AGH Politics Avenue. Podcast or set trend na mekos make headlines na jemre na EDB exomo ewo hakse ni di mane ahobraksi mu. Oni a be shock say yanko political highways ni mu eja edem a enya asem koto Accra. Na ringa na say chairman Wontumi ene occupy mu ewo court na after court ruling no na on the 16th of March and court ebitimi decided say Wontumi we free man and nak say obetimi opinion defense court na the woman sen lawyer and the appear could be akasa abra a free court no yemhwe nsema hodwa yen lawyer if we egu ho shana so am say asking H Politics Avenue yonko Wontumi legal practitioner na so ye abra oboyin chiremu aha H Politics Avenue.
This afternoon, the Accra High Court has set March 16 to rule on Wontumis' submission of no case in the matter involving Akonta Mining, granting unauthorized persons to mine at the Samurai Boy concession. On February 4, 2026, state attorneys led by Deputy Attorney General Dr. Justice Shremsai closed the case of the prosecution against Chairman Wontumi and his two co-accused, Kwame Entry, who is at large, and Akonta Mining Limited. It is the case of the prosecution that Chairman Wontumi, without obtaining authorization from the minister, gave his mining concession in Samurai Boy to people to use for illegal mining activities, an accusation he has denied. Lawyers for Mr. Wontumi have been speaking to my colleague Lord Idwasari. Let's take a listen to exactly what they've been telling him.
That will be the date for the ruling of our submission of no case. If it is upheld, then that will be the end of the trial. If the judge thinks that we have to open our defense, then we'll make that statement also to us. And we'll begin our case also by opening our defense. But I'm very hopeful that based on the submissions made, looking at the evidence before the court, I'm hopeful that the judge will be.
Well, we know that Wontumi is standing trial for quite a number of charges slapped on him. What are these charges? Let's walk you through them right now this afternoon. And then we connect with my colleague Lord Idwasari, who is on standby for us as well this afternoon to get an understanding as to the arguments canvassed by his lawyers in seeking to have the court rule that the prosecution has not convinced the court beyond reasonable doubt that he is guilty of these charges, which I'm about to walk you through. And the first is undertaking mining operations without a license is one of the many charges Bernard Ntriboisiako is facing. Also, he is facing a count of felling trees in a forest reserve without authority. He is also answering questions as to erecting buildings in a forest reserve without authorization. So these were charges for Akonta Mining Company Limited. For Bernard Ntriboisiako, who is the individual, right, the man, he is facing a charge of undertaking a mining operation without a license, abetting the unauthorized felling of trees, as well as abetting the unauthorized erection of buildings. And he's pleaded not guilty to all of these charges as well. And then we know that Kwame Entry, who's the third accused who's at large, is also facing charges for jointly with Wontumi for undertaking mining without a license, abetting unauthorized felling of trees, and abetting the erection of unauthorized buildings as well. Then there is Edward Akwaku, who is the general manager, but he is right now a prosecution witness in this particular matter. But as at the time, he was a fourth accused in this particular matter, but subsequently, he's been discharged by the court and is serving as a prosecution witness. And so I'm going to just skip the charges leveled against him. And then there was the operations manager as well, Akonta Mining Company, who's also been jointly charged with Akwaku for undertaking unlicensed mining abetting for the felling of trees and aiding the construction of unauthorized structures. These are the charges for which reason he is to answer questions in relation to. Let's take you to my colleague Lord Edwasare now, who is getting us details right now from the court as to what transpired today and the arguments that were canvassed by lawyers for Mr. Wontumis. Lord, thank you very much for joining us as well this afternoon. The lawyers for Mr. Wontumis say prosecution has not proven a case against their client, hence they want the court to rule a submission of no case. Talk to us about it and the arguments as well in the courts today.
Right, Marina. So primarily today, when the case was called, the Deputy Attorney General, Dr. Justice Remsai, he informed or notified the court that he had filed a response to the submission of no case filed by Wontumis lawyers. Now, they had already filed their submission of no case, and so they relied on all that. Today primarily was for the Attorney General to indicate response, basically urging the courts to, as it were, dismiss the submission of no case, insisting that Wontumis has a case to answer, looking at how the thread of issues had gone across as far as the prosecution witnesses, what they've told the court, all they've been indicating to the court, relying on that, indicating that for this reason, it behoves on the court, as it were, lets Wontumis open his defense because they believe the prosecution has proven enough. Now, Andy Appiah, the lawyer for Wontumis, he insisted that, well, as far as the prosecution says what they have to say, they still believe that Wontumis has nothing to prove. He has no case against him because even the fourth prosecution witness, who, like he indicated, was part of Wontumis' crew, some of his narrations in court were not consistent, looking at the fact that he indicated that there were some biases and then contradictions. And so he indicated that the court needs to rely on all this and show that Wontumis indeed has no case to answer. So in this case, the presiding judge in the matter, Justice Kokubite, then sets March 16, which is next week Monday, to rule on whether Wontumis will walk or if indeed he has a case to answer, by which point then he'll be asked to rely on his witnesses, and then the case will move on from there. Because at that point now, Marina, know that the trial itself will now begin.
Right, and for prosecution, how did they take this argument as moved by lawyers for Mr. Wontumis?
Well, they indicated that all that they have to say is contained in the response that they have filed, 12-page response filed by the Deputy Attorney General, and essentially they didn't make any open arguments in court because they said they're going to rely on that, and so it behoves on the presiding judge to consider all these documents that have been filed by both parties and then make a ruling. She indicated that indeed it's a very short ruling because it's a matter of saying the application has been granted or thrown out, and so it's basically either a tipping point or a straight edge.
Right then, Lord, thank you very much for those details. That's my colleague Lord Edwasare helping us appreciate exactly what it is that's been transpiring in relation to the case involving Bernard Ntwi-Boesiaku, known as Chairman Wontumis. But I know as well, or we know as well, that this afternoon, as the Office of the Special Prosecutor has dropped charges against the Director of KEL Logistics Limited, Albert Ankra, after the fourth accused agreed to testify as prosecution witness in the ongoing criminal case against former NPA CEO Mustafa Hamid and 9 others. The accused persons have been charged with multiple offenses, including stealing, extortion, and money laundering. They have all pleaded not guilty and are on bail. Lord, talk to us. What happened in relation to this matter as well in court?
Well, so in this matter concerning the former Chief Executive of NPA, Dr. Mustafa Hamid, and then the 9 others, the principal prosecutor from the Office of the Special Prosecutor, Adelaide Kopi-Wood, indicated that lawyers of Accra, together with he himself, came to the offices of the special prosecutor and informed the official that he was misled into carrying out certain acts, for which reason he basically surrendered himself and agreed to serve as a prosecution witness against the others. And so the principal prosecutor indicated to the court that in lieu of this development, it means that they'll have to
of their action after yesterday's inconclusive meeting. Here's what he had to say.
The Pharaoh is going back to consult with government and get back to us.
And you are satisfied with that?
Yeah, we are satisfied with it now.
You are going to consult government in what way? Because this is a finalized something, concluded and ready to be implemented.
Well, I cannot give you further details. All I can tell you is that the Pharaoh is going to consult government and get back to us. So we are waiting. As at now, National Executive Council has not suspended the strike.
Have you considered the impact of your strike nationwide? Because people are complaining the weight and the gravity of your strike.
The people should also consider the impact on our pockets. Our children are being thrown out of school. We are having issues with our spouses. And now it used to be the case that civil servants are held in high esteem, but we are highly demoralized. So they should also consider that.
Labour expert Senyo Ajabing is joining us for a bit more on this story. Senyo, it's good to talk to you again after such a long time. But Senyo, we've seen these situations before. We know that once talks have resumed, Labour should call off the strike. Is Labour in the wrong here?
Good afternoon, and then also to our listeners. Clearly, you can see that not many people are quite pleased with this particular strike. Gone are the days when sometimes Labour calls a strike and they have some form of backing. I mean, public sentiments are with them and people try to sympathize with them because they seem to be fighting a good cause. This particular strike action is very surprising. And I think that I can only say that we need to stop using this old traditional tactic of bullying to try to resolve labor disputes. It's so archaic. It is out of spec, and we need to start focusing on using proper engagement ways of having our dispute resolved. And this is extremely disappointing and surprising. And even when they are being engaged at the table, they are still on strike action and can boldly say that council has still not called off the strike. I think that the time has come where unions declare illegal strike actions and it is so determined by either the Labour Commission or a competent court, the executives of those unions must be called to some form of action. Because we cannot continue like this as a country.
Should the commission take this matter up in court, especially?
Well, you are aware that they have been invited to a meeting tomorrow at the National Labour Commission. And having gone before the National Labour Commission, they are going to be notified and they are going to be instructed, ordered to call off the strike because they would be in the cooling off period at the time they appear before the National Labour Commission. And beyond that, if they do not call it off, then of course, National Labour Commission can take an order from the court to force them to go back to work.
And so going into that meeting, Senyo, what should be the posturing of the National Labour Commission?
Come again?
I'm asking that, I mean, you have given instances at which the Labour Commission should resort to the court. But tomorrow there's that crucial meeting between CLOGSAG leadership and the Labour Commission. What should be the posturing of the Labour Commission if it wants to get to the bottom of this tomorrow?
Well, the Labour Commission has no choice than to follow its mandate of being a neutral arbiter in the matter. The National Labour Commission is a neutral body and has to listen to both sides and ensure that somehow they follow the interests of both parties and help the parties to resolve the matter. But the National Labour Commission also has some powers, and that is where when they kind of engage you and as a union or as a party before them and you continue to breach the law, they have the mandate to be able to get a court order and impose that on you. So I am looking at the Labour Commission having a conciliatory posture as it has always had, and a neutral, third party, help the parties to resolve the dispute, gently inform these people to go back and call off the strike, but still indicates to them that if you do not call off the strike, we will be forced to use the force of the law against you and take a court order to compel you to go back to work. Because you see, the whole rule of engagement in labor is that you cannot be on strike while at the negotiation table.
Absolutely.
That is not something that can be allowed. And the unions have to know that they cannot continue to breach the principles and basic rules of engagement. It's so disappointing.
But Senor, in the reality of things, we know why that happens a lot of times, because it's able to twist the arm of the employer who is trying to make sure that the impact on workers, on the public is mitigated, right? And so realistically speaking, while the law may be on the side of the employer will also have to deal delicately with this matter. That's correct. So then my question will be, what would you expect government to do now to delicately handle this matter, get labor to get back to their offices and attending to the public, but at the same time, get labor on the other hand as well to do the right thing and follow the law, if possibly to the letter?
Yeah, I think that the employer in this case, government, needs to continue to encourage the other side because they are social partners, and labor disputes cannot be resolved through antagonism and threats and hardcore posturing. So they need to continue to encourage and reach out to the other side to go back to work while they rely on the legal authorities, that's the National Labour Commission and possibly courts, to properly resolve this matter. The employer has certain rights under the circumstances where their employees go on unlawful strike action, but normally that should be the very, very, very last.
We and some who team cause channel so, Mammy and I was so Jim Raider, Senator Body in the Dumbi Erumini, you be saying a small strong so.